I'll let the clock tick over before I.
Hello, I'm Dondi Plowman, Chancellor here at UT Knoxville. Congratulations on the 10th anniversary of UT Social Media Week. What started with an idea and funding in 2012 from two alumni, Adam Brown and Ed Patterson, has evolved into an annual event that continues to grow each year. Social media is a powerful tool and one that provides direct access to your community. Over the past year, I have especially found social media a useful way to connect with our students, faculty and staff, and alumni when we can't be together in person. But social media also comes with great responsibility. As easy as it is to share information and ideas, it's also a swift way to garner negative attention and thoughts around a subject. As you continue to expand your knowledge utilizing social media, I encourage you to find ways to be a bright light in a space that can at times be challenging. Have a great week learning and connecting with others, and congratulations on 10 years of education, collaboration, and growth in the social media realm. Thank you, and go Vols.
You're muted, Rob. Yeah.
Stuart, should I begin?
Rob, no, I'm here. So good afternoon, I'm Professor Brotman. It's a pleasure to welcome everyone to what I think is going to be an interesting panel. So we are operating in real time, which means that we have an opportunity to do a quick poll. We're going to be talking about something called Section 230 of the Communications Decency Act. And I think probably the first thing to do is to ask our audience whether or not they've heard about this at all. Certainly in the past year, this has gotten a lot of attention, and be interested. So we'll do a quick poll right now and just see yes or no, whether or not you know about Section 230 of the Communications Decency Act. I know by the end of our discussion today, the answer should be 100% yes, but I want to at least have a little baseline for where we are. So if you just check off there on the poll, yes or no, do you know anything about Section 230? And then press submit. Great. So while you're doing that, let me just give you, so we have a 39% yes, and the majority, the vast majority, 61% of you say no. So we're going to have an interesting, both a discussion and also hopefully give you some more information and perspective. So 25 years ago, the United States Congress enacted something called the Telecommunications Act of 1996. Now, the Telecommunications Act of 1996 is a big piece of legislation, but it's actually an amendment of another law, which is called the Communications Act of 1934. And over the years, that act has been amended, sometimes with relatively small amendments, but in 1996, Congress essentially enacted a large series of amendments and put them under the umbrella of the Telecommunications Act of 1996. Well, that was a very controversial piece of legislation, and at the time, President Clinton was our president, and Congress had some real resistance whether or not they wanted to enact this law. And in particular, some Republican senators indicated, as well as a few Democrats, that they would like to see a special series of amendments within that law, and those amendments would be called the Communications Decency Act. And that is part of this Telecommunications Act, and it's also part of the Communications Act of 1934. But what you will hear many times is when Section 230 is referred to, it's called Section 230 of the Communications Decency Act. So this is a federal law. The ACLU challenged the Communications Decency Act in federal court because one of the central provisions of that act was essentially to be able to give government the power to restrict what was called indecent communication over the internet. And that was a case that got litigated, ultimately reached the United States Supreme Court, and the United States Supreme Court ruled that that was a violation of the First Amendment, that government had no right to essentially restrict indecent communication on the internet. And that was a case called Reno versus ACLU. But another part of the Communications Decency Act was Section 230. And Section 230 was created in part because those who were going to provide content over the internet did not want to be liable for that content, whether it was indecent or not. So as part of a legislative bargain, there were two provisions put in. One, the provision about indecent communication, and the other, which essentially affected the liability of those who might communicate content over the internet. Obviously, 1996 seems like a galaxy far away. We now have a world of social media, and obviously we have dominant players such as Facebook and Twitter, and we have smaller and emerging players such as Parler. So Section 230, as you'll hear, applies to all of them. And so we're in a very interesting political and social era right now because as of last year, as you'll hear, there's been quite a bit of activity in the executive branch and in Congress to perhaps reconsider whether or not Section 230 is working, or if it's not working, whether it should be changed. So I think that gives you a little bit of a background, but I now want to turn it over to the Pioneers Chair and Professor of Telecommunications and Law at Penn State University, Rob Frieden, who will begin to frame exactly what we're talking about. Rob?
Unmute. Okay. Thanks very much, Professor Brotman. I trust you all can hear and see me. This is live. I happen to have a very loquacious corgi in the background. I have treats just in case this transfer student wants to chime in. I have it on good authority that spring is arriving in Tennessee, and you're going to have a high of 62 degrees or so. That won't happen in State College, Penn State, where I am, until, I don't know, May, June. And in fact, I have a lame joke to start the presentation. We have 4 seasons at Penn State: nearly winter, which starts in August, winter, September, still winter, continues into May, and then we go into road repair. I don't know if that happens in Tennessee, but a lot of road repair as the 4th season. I wish I could be with you. I have it on good authority also that there are a number of brew pubs, and Professor Brotman, you're going to have to take me to the Abridged Beer Works or the Black Horse or the Bowler Beer Works or Schutzbrau or High Wire. That's a lot more than we have here. Now to the presentation. Right in the first slide here, you see a relatively legal sounding, but not terribly helpful sentence there, which in effect kind of gives you a sense that somebody or some group of speakers are going to be put into a category that might protect them from some degree of liability of the sort. Going back to what Professor Brotman mentioned in terms of looking at the internet as a major medium for access to information, communications, and entertainment, U.S. Congress was concerned that children, who will be a substantial part of the audience, should be protected from harmful content. There's been a move over the generations to protect children from harmful content, be it transmitted over this new medium, the internet, or from television, radio, and the like. Unfortunately for Congress, that act of creating legislation that achieves the goal of protecting children also has to respect First Amendment rights of adults, and attempt after attempt, the Congress has failed. It's failed to craft language that's unambiguous, narrowly drawn, so it's not overbroad and harms or restrains, chills speech appropriate for adults, but perhaps harmful for children. Notwithstanding the failure to create this broader protection of children, one part of the legislation prevailed and was allowed to enter into force, and that is Section 230 of the Communications Decency Act. And that simple sentence you saw on the cover slide has generated strong support and opposition. Some believe that the internet is as robust as it has been and will be thanks to this provision. Others think that it's quite troublesome, and I think the presentations that you received today will showcase that a big dichotomy.
Professor Frieden, excuse me, is it possible to go back to the first slide just so we have a little more focus on the actual language of what Congress has provided here?
Right. Can you see that? It says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So that's legalese, but if you sort of parse through it, and that's what we're going to do today, you get a sense that the intermediary, the social network, the platform standing between content creators and the audience and the subscriber, children, adults, what have you, receives a safe harbor, an insulation from liability. So here's a picture of a safe harbor. It's where that's where you want to be during a hurricane or a thunderstorm and the like, protecting you from penalties and oversight and regulation and lawsuits and rules. And that's what Section 230 does. It provides the conduit, the intermediary, an insulation from liability for the content that conduit delivers to consumers, to subscribers. And that content can be harmful, such as pornography or crime or hate speech, defamation, and the like. So this is a sort of get out of jail card for the intermediary, including social networks, including the Facebooks and the Twitters and the like. Now, what we have in traditional law is a view that if you are involved in the creation of the content, the curation, the moderation, the editing of the content, you are complicit. You're involved. You're a co-conspirator. You're going to be held responsible for the content. But on the other hand, if you're like a library or newsstand, a distributor of content, librarians are not held to a standard to know each and every book, each and every magazine that's available at the library. They're going to be exempted from liability. So the goal was largely driven by protecting children from harm and allowing the intermediary, the platform, to operate as good Samaritans. Good Samaritans can unilaterally, on their own accord, protect children from harm. And that's what Congress was trying to do, to allow these intermediaries, without fear of liability, without fear of lawsuits, to take down content that would be harmful for children. But the flip side is that the provision also allows these platforms to escape liability if they are the unwilling and unknowing conduit for the delivery of harmful content. So there's a tension there, and there's also First Amendment issues involved. In particular, the difference between what's appropriate and lawful for children versus what's appropriate and lawful for adults that might not be appropriate for children. So to continue, I've used the word platform and intermediary, and if there are any economics students in the audience, there's something called a two-sided market, which identifies these platforms serving both downstream subscribers, consumers, but also upstream advertisers and content creators. Useful definition that was coined not so long ago in the New York Times is that a platform is a software framework to provide a interface, intermediary platform between audiences who could scale up and have a global geographical coverage downstream and then upstream to sources of content. And of course, that's exactly what a platform is. That's exactly what Facebook is. Facebook is a platform intermediary that is largely driven by achieving scale, getting as many subscribers as possible, and subjecting those subscribers to as many advertisements as possible. You want to make something sticky in the sense that the consumers, the audience is engaged and spends a lot of time on those platforms. And that's in economics called positive networking externalities. Put it this way, the more people on Facebook, the more people on a particular social network, the more revenues Facebook can accrue. But also, given the algorithms and the nature of building that subscribership, the intermediary actually has a perverse incentive to not be involved in the creation or moderation of the content, curation of the content, editing of the content. And toxic and very harmful content certainly is going to flow through. The court of public opinion seems to be shifting maybe significantly against social networks, particularly in their inconsistency in terms of who they deplatform. That's a new word. Deplatforming means that you take people off the platform, you temporarily or permanently revoke their subscription to the social network and their opportunity to post. First Amendment, as I've mentioned, is involved here. It doesn't prohibit non-governmental restrictions. The First Amendment is aiming to prevent or substantially constrain government repression of speech absent compelling circumstances. So a Facebook, a Twitter in the terms of service can reserve the option of revoking or deplatforming. Now, how did we get here? We got here because before Section 230, back in the early 90s, there was a state court case where Prodigy, which was one of the first internet access providers, was providing a very minimal degree of editorial control over what are called listservs or bulletin boards. These are the sort of precursors of social networks. And Prodigy was treated as a publisher responsible for content that was not created by Prodigy, but was delivered by Prodigy. Impermissible content, in this case, potentially defamatory content. There was a movie I recommend you watch if you haven't seen it before, The Wolf of Wall Street. There's this guy, Leonardo DiCaprio. He had a lot of fun in this movie. You might have seen him in this one involving a cruise ship hitting an iceberg. He didn't seem to have a very good experience there. Spoiler alert: he dies. He freezes on in the ocean there. But the wolf there, who was quite an aggressive salesman for pump and dump stocks, sued Prodigy and Prodigy was not treated as a neutral conduit. Prodigy was held liable. So perversely, before we got the Section 230, Prodigy and other websites had less of a liability risk if they saw no evil, heard no evil, and unknowingly distributed evil content, but weren't directly involved in it. If you're proactive, a good corporate citizen, a good Samaritan, you became liable. So Congress responded by allowing moderation and curation of content, and to do so without risk of lawsuits. Is it wise public policy or legitimizing censorship? Well, I'll defer to my other presenters for that further investigation, but I see my time's pretty much run its course. I'm glad to answer any questions, and thank you for your attention.
Thanks, Professor Frieden. Great overview. By the way, we have a Q&A or chat function, so if any of you want to ask questions or if you want to get anything clarified, just put it in the chat box. I'll be moderating it, and hopefully our panelists will be able to respond to that. So I'd like to now introduce John Adami, who is the General Counsel for our senior senator in Tennessee, Marsha Blackburn. And John has been very active in working with the senator and obviously the legislative team and on Capitol Hill. And it might be useful, John, if now that we have the background from Professor Frieden, to give us a little sense of why government, particularly Congress and the previous and to some extent current administrations, might be interested in changing Section 230. John?
Thanks, Stuart, and thank you to the University of Tennessee for inviting me to speak on this panel today. I wish this could have been something we had done in person. I understand this is quite a fun conference to attend. You know, I have kind of an unusual role in the office. We're on Commerce, Armed Services, and Judiciary committees, and I handle all of our tech issues across this portfolio. I mean, it'll range from content moderation, spectrum policy, pretty much everything that revolves around the phone. And so we got to a place where you can not deny the fact that social media has changed the world. And whether or not that's a good thing depends on whether or not you're making money from it generally. Democrats and Republicans might agree that there's a problem with respect to content moderation, but I think the agreement ends there. The way that people have been approaching problem solving, it's generally, do you think that companies have a responsibility to do more content moderation to prevent certain harms that you've identified, or do you think that they need to do less and allow more speech to be flourishing on the platform? Typically, it's Democrats that want the former and Republicans want the latter. I think it might be a little helpful if I gave just a quick procedural background on how this functions generally in Congress, or if we're talking about executive agencies. Basically, bills, they're introduced House or Senate, they're referred to their appropriate committees, legislative work begins, we have hearings, lobbyists and constituents will all come in and tell you why what you're doing is the greatest and worst idea that they've ever heard at the same time. Occasionally, you get to vote. The bill can move forward for consideration through the committee to the full chamber. And right now, the Commerce and Judiciary committees are the committees that have jurisdiction. It typically comes down to what authorizing statute you're seeking to amend. And for a professor, this is the Communications Act of 1934. Generally, when we're thinking about this from a legislative standpoint, from a legislative council standpoint, we just call it Section 230 of the Communications Act. A lot of what had been in the Communications Decency Act was actually thrown out by the court. The judicial review process is a very significant thing that we have to be considerate of whenever we're trying to craft policy. When you are looking at this debate, the rails come off pretty quickly. People say the internet is a lot different now than it was in 1996, and well, that's self-evident. Section 230 wasn't really about neutrality or taking a puritanical approach to the internet, and whether you're a platform or a publisher, it's kind of a distinction without a difference. You often hear people bring these arguments up when they want to impute the traditional responsibilities of newspaper publishers onto platforms like Facebook and sue for, well, we're still trying to figure that out sometimes. You know, taking accounts down isn't the violation of the First Amendment. And I think that's something that we've gone over already so far today, because it just protects the companies from the government, not the other way around. And even if there isn't some harm, there's still something about it that feels wrong. It's contra to the spirit of the First Amendment. And so it's incumbent upon us as lawmakers to figure out how we strike this balance between what it is that the public is feeling about the way that technology is changing and the way that markets are changing, and what our role is to step in and shape that to the extent that there is one. If you're thinking about Section 230, to the extent that you ever do, you should think about it as a procedural mechanism. Originally, the idea was to bar frivolous lawsuits when the specter of a lawsuit could just completely destroy your startup. The fact that many of these companies that we're talking about now are highly profitable shouldn't really change the way that we're analyzing this problem. That's really just looking for deep pockets, not trying to protect people. I think the Wolf of Wall Street example, or Jordan Belfort, was kind of an interesting way to approach this, because it shows that when the courts do take a path that Congress doesn't agree with, oftentimes they can step in and change the law to reflect the way that we think it should be. And that's something that you saw with former Congressman Chris Cox and now Senator Ron Wyden, who pushed forth this small change that ended up having a really large effect on the way the internet functions. Ultimately, this comes down to questions about corporate responsibility. We have these debates where we'll say that, Section 230 does this or it does that, and the First Amendment does this and it does that. But really what we're thinking about is what the root cause of our discomfort is. I think you're seeing that reflected in legislation that was recently introduced in the House by two Democrats on the Commerce Committee over there. They have this idea that if you're putting out content as a broadcaster, you should be responsible for any misinformation contained therein. And they're really thinking about punishing Fox News for political things that they're uncomfortable with. And that kind of gets us into this area of inherent subjectivity, and defining what that means really kind of brings us back to the reason that many conservatives are fearful of big tech's motives. So, I think another good example about this, thinking about recent events and markets, the short squeeze that happened on hedge funds for a now infamous subreddit brought a lot of these issues to light at the same time. When you're done untangling the web that's high frequency trading and putting aside order flows and clearinghouses, what you're left with is ultimately a question of who owes what duties and to whom. Did Reddit have a responsibility to monitor and notify the SEC once flow of information on upcoming activity related to GameStop erupted? Who did Robinhood have to put first, the stability of the company or the trade request by the users? You're allowed to trade free on their platform, and that's generally not the case in most places. So when something's free, you ought to be thinking about whether you're the customer or you're the product. And that's the place that we found ourselves with a lot of the other very large tech companies right now that are providing services in a two-sided market, where you've got to think more deeply about what transactions are taking place, what their motives are, and where can Congress step in to be able to make any improvements here. We've sponsored several different pieces of legislation. In the past Congress, there was executive action from the last administration requesting that the Department of Commerce look at initiating a rulemaking at the Federal Communications Commission. And even the FCC and the FTC both decided they didn't really want to pursue that. They kind of felt that that might be government regulating free speech, and it just stopped there. But that doesn't mean that we're done acting here, and it doesn't mean that there isn't more work to be done. So, to the extent that people have questions, I'd be happy to answer them. I feel like having this inside track on where a lot of these things have been moving might be helpful.
Great, thanks, Don. So I just had a quick follow-up question, which is obviously we now have a new president and new administration. And I think one thing that was interesting is that certainly during the campaign, both the Trump campaign and the Biden campaign had some general agreement, if not on the details and on the concept, that Section 230 needed some level of further analysis and maybe some reform. So just in terms of where things are now, and obviously where you sit, so do you sense that the Biden administration will be as focused in this area as the Trump administration was?
I do think they'll be focused, but for different reasons. the way that they're looking at platforms like Twitter and Facebook, they want them to take more aggressive steps to moderate content, and whether we're talking about hate speech or misinformation or things that may or may not have led to the recent Capitol riot. There are a lot of things that they are looking at companies to take on in terms of additional responsibilities. And if they don't meet those responsibilities, then they'd like to use the threat of a lawsuit to be able to change their actions.
Great. So let's turn to Jamie Suskind. So Jamie is the Vice President for Policy and Regulatory Affairs at one of the leading trade associations in Washington, which has been following and certainly has been developing positions in this area. So I'll turn it over to Jamie, and I think it would be helpful, Jamie, to just start out by giving a little overview of your association, and then obviously reflect on both what John has talked about and in particular where the trade association that you represent feels that either changes should be made or shouldn't be made, and why. Jamie.
Great. All right. And if you can't hear me, just holler. So I have some slides, but I will skip through some of them. But thanks, first of all, to the university for inviting me to participate today. As Professor Brotman said, I work at the Consumer Technology Association, and we're always pleased to participate in discussions on this particular topic. So we have about 2,000 member companies all over the country. They range from the big companies and brand names you think of, right? We have Facebook, Google, Twitter, Amazon, Intel, Samsung, all of it, the big guys. And then we have the little companies too. So like the guy who's getting started creating a connected alarm system in his garage. And so we have most every year the Consumer Electronics Show. This year was our first all digital show, but I'm sure some of you have heard of it before. And so, we have displays and exhibits from all of our members and then some non-members. So, we have a vested interest in this, both in representing our members and also in just preserving an innovation environment for tech. So I'm going to attempt to scroll through. Okay, good. Scroll through some of this. I don't know if I can actually go back. Let's try to escape out and I'll just go back to that slide that I need. Great. So actually, I wanted to start by asking folks to give a quick thought back to your life in 1996. And since I know that many of you are students, in 1996, you might not have even been born yet, or you were just being born, which is funny to think about. So in 1996, I was about 16, and it was right about that time that I actually discovered the new fad of the internet. So it's actually embarrassing to talk about now, but my friends and I used to use Prodigy, and we used to use AOL to talk to each other in chat rooms, but more importantly to us at the time, we tried to do it to talk to celebrities that we thought were cute. And one time we actually met somebody who claimed to be the actor Elijah Wood, if you guys even remember him. He was in Lord of the Rings, Frodo. But probably it actually was just some random weirdo. So thank goodness Congress in its infinite wisdom actually enacted COPPA about that same time. But the point of that is just to show you, not that I had no life, but that is probably true, but that 1996 was actually a very different time, as has been alluded to here, for the internet and for online platforms. They were both just getting started. And at the time, we did not know if those technologies would succeed or if they would be failed experiments. But what we did know at the time is that the internet and then platforms like Prodigy and CompuServe gave people an ability to communicate like they've never had before. And so as Professor Frieden shared with you, this raised new questions about whether and how speech on these platforms should be moderated and policed, and what the legal responsibilities for doing that were for the platforms that hosted this speech. So, the law as the platforms developed really wasn't clear either for internet users, for people like you and I who were posting on the internet, or for the companies that were taking the initiative to start these new services. So as you can see, Congressman Cox, who John mentioned, was one of the drafters of Section 230, along with now Senator Ron Wyden. And so there's a quote here from him. It struck him that if the rule, meaning the Stratton-Oakmont decision, which is the Wolf of Wall Street implication from before, were to take hold, then the internet would become the Wild West and nobody would have any incentive to keep the internet civil. And so I've talked actually several times in the last year to Congressman Cox, and we've worked together on advocacy before the FCC when this issue fell to them. And, you know, I think he would actually say the same thing now that he would have said then, right? Which is Section 230 actually ended up working exactly as Congress intended it to do and exactly as the drafters wanted it to work. And so I do know, right, that an argument that has been made, particularly NTIA made it when they were dealing with filing their petition at the FCC, is that Section 230 is no longer necessary because the internet now has developed and it's thriving. You know, there's a lot of different sites out there, and that suggests that 230 is somehow past its time. So and I think by extension, probably Congressman Cox and Senator Wyden would actually assert the opposite, right? That 230 has played a really vital role in the development of the competitive internet and all the innovation that we see today. And that, in fact, we actually need 230 to stay around as we move towards things like 5G and even 6G, that was the conversation, and advanced applications that run over those services, things like AI, and then augmented and virtual reality, telehealth, connected agriculture, which is probably a big deal in places like Tennessee. So things like that. Without Section 230, you know, I'm not sure that we would see the same level of innovation and development that we actually had seen to date. Let me scroll here. Here's just a few quotes or sort of descriptors that other people have used to describe Section 230. So the 26 words that created the internet, and then the most important law protecting internet speech. And then from Wired, the obscure law that created our flood-broken internet. I'm going to actually skip pretty much the background because the professor gave you most of that, but I'm actually just going to stress two things, right? So from our perspective, Section 230 stands for a very common sense principle. First, that responsibility for online speech lies with the speaker and not the person who carries that speech. So if I go on Twitter today and I say something ridiculous, which I tend to do on Twitter, feel free to follow me if you like, you'll find me. You know, that is my responsibility, and I should pretty much own the liability for the dumb things that I say, absent certain exemptions. Let me scroll to the next slide. You might hear, if you decide to read about online, particularly some of the pundits who debate this issue, that big tech has absolute immunity against everything that happens on their platforms. And that's actually not true. There are several exemptions that are built into the law, one of which was added a few years ago as part of the FOSTA-SESTA issues that were up on the Hill. So things like federal criminal laws, sex trafficking laws was FOSTA-SESTA, IP laws, there are certain state laws, other state laws not, and that's sort of where the big controversies have come in. And then communications privacy laws, things like ECPA. So, you know, you may hear that big tech is absolutely shielded, but that actually isn't the case. And so there is an obligation to comply and to work with law enforcement in many of those instances. And a lot of the platforms, I mean, they do, and they take very affirmative steps to do so. So I did want to just stress those points. Some of the history has already been alluded to here, but in May 2020, then President Trump had put out an executive order on social media. It asked several agencies to do different things to look into how social media practices were working. And it directed, in particular, the FTC to take action against social media companies that were basically being politically biased as part of its Section 5 unfair and deceptive practices authority. The FTC said no, they said that's political speech and we just don't do that. That chairman has left the agency, but I think it's unlikely that the current acting chairwoman would be interested in this. Similarly, as John said, NTIA was directed to petition the FCC for a rulemaking to propose rules to clarify the scope of Section 230. Chairman Pai, who was there at the time, declined to do so. And acting chairwoman Rosenworcel will not be doing so, and she said so publicly just the other day. So that's, I don't think Biden has rescinded this, but it's not going anywhere. As has been suggested, President Biden, my video doesn't work, so sorry. He similarly has expressed skepticism of so-called big tech companies. He's not a fan of 230. Similarly, his nominee for Secretary of Commerce, Rhode Island Governor Gina Raimondo, has expressed her own views that Section 230 needs some reform. But she did say, she recognized that there needs to be a balance and that we also have to be thinking about innovation and the jobs created by these platforms and by other tech companies, by the way, who are not just like Facebook and Google and Amazon and the ones that sort of get all the heat, right? I mean, this pertains to any online platform. So you look at your next door, you look at Craigslist, you look at Flickr, you look at Vimeo, you look at all these sites. It doesn't just actually pertain to like the big guys that tend to be in the news. There was a one I had here. Yes, the Supreme Court, Justice Thomas actually about the same time last fall, right around the election, that sort of all of this hit the fan, also came out and talked about how he felt the case law was not clear and that there may be a role for the court in trying to figure out sort of where the precedent should be and sort of how lower courts are interpreting Section 230 might just not be correct. So as of now, there's no case there, but I guess he is remaining sort of open to seeing where that goes. And then obviously John could talk about this more, but there are so far, I think there are 10 bills that are floating around from just this Congress. So in the last month and a half, last year there were many more, and I suspect many will get reintroduced, but here are some of them that have been introduced. So obviously, as he said, there's still an appetite up there for having this conversation. So why some of the calls for reform? As John mentioned to you when he spoke, there are conversations about conservative bias. For those of you who followed former President Trump on Twitter, he talked about it often until he was, I guess, deplatformed from Twitter, which then made the conversation flare up again. So that was fun. And as John also said, from generally more of the Democrat side, there are a lot of claims about disinformation, about what I kind of refer to as under moderation, dangerous content allowed on platforms. So things like sex trafficking content, child pornography, drug sales. There's other, there have been bills introduced to talk about sort of other things like illegal apartment subleases. So stuff like Airbnb was really the focus of that. Other harmful content, Congresswoman Clark has a discussion draft floating around about sort of racial bias on websites and sort of the content that minority communities are seeing or not seeing on the internet. And then Senator Rubio has a bill, the Act, that is sort of, it deals with 230, but 230 is really not the crux of it. It just happened to modify something in 230, but it was really dealing with more cyber issues. But as John said, right, in my view, there's not a ton of agreement here from the policymakers about what the problem is, other than, people are displeased with tech and big tech companies for different reasons. And so I am skeptical that until folks can sort of coalesce around an actual concern that is shared, right, bipartisan, because these days our margins are very slim in both the Senate and the House. I'm not sure that anything is actually going to happen on this unless it's like a flat out striking 230 from the books altogether, which I think that's a bad idea. But I'm very skeptical that until we actually see some agreement, then things will move forward. So in CTA's view, some of the big points that we like to talk about, first of all, is that Section 230, which I know has come up in this conversation already, that it protects platforms from frivolous litigation based on claims that they did too much or too little to moderate third-party content posted on their sites. I mean, that was really, right, that initially was the point of the law as drafted by Congressman Cox and Senator Wyden, right? We want companies to not either, moderate too little or moderate too much. We want them to be able to do moderation within the realm of what is practical for them to do, but also moderation that's responsible. And the concern, right, is that if we go back to the Stratton Oakmont days, once again, the incentives will not be there for folks to take those practices and sort of do responsible moderation. They'll either not do it at all or they'll do it too much. I would also note, right, that lawsuits obviously are not helpful for innovation. And if platforms have to be subject to, or they could be subject to lawsuits for all of these moderation decisions, why would you ever want to run a platform? I think that would just discourage folks from doing that. And we would also say that if every moderation decision sort of becomes a trial, that would definitely slow down the discourse of free speech. So like, for example, right, I'm on Facebook and I belong to several groups where, moderator has to approve what you post before you can be part of the group. And I mean, you agree to that up front, so I'm okay with that there. But if you have to have Facebook agree to your status updates in every single instance, I don't think that necessarily contributes positively to the level of discourse that you would be seeing on that site. That just doesn't feel very free. Similarly, our view is that, as I've said before, Section 230 allowed the internet to grow unfettered by regulation and contributes to the free and open dialogues that we see online every single day. In particular, I feel that this is a very US thing, right? If we didn't have 230, I don't think that the internet would have grown in the US by the leaps and bounds that it has. And, we don't think that innovation, in fact, that the US would stay the leader in innovation. And so these are points that we actually made when we asked the FCC not to take action on 230. And I think they agreed, because ultimately they didn't, is that, for those of you who sort of follow this issue, right, the US and China have been neck and neck in kind of an innovation battle, and China would like, frankly, nothing more than to see the US fall and let them be #1 in innovation. And to us, I mean, that's not helpful for our companies. That's not helpful for our consumers. That's not a thing that we would frankly like to see. So we think that Section 230, in fact, which is like a very sort of US specific law, we see that as, very special for the US and the thing that will help us keep our place as #1 in the world in innovation. The last thing that I would note is that, there's a lot of conversations about whether platforms should be neutral, either under the First Amendment or just sort of as a matter of, I guess, like ethics or politics, perhaps. So, I mean, #1 has been said, platforms are not the government, right? So they're not, as we have said, we've established, they're not subject to the First Amendment to sort of be neutral in that way, right? In fact, platforms, actually, the Supreme Court has said that they themselves have a First Amendment protection when they are moderating content. So, they actually are shielded from the First Amendment, by the First Amendment, to do these decisions and make them. And I think the other thing that I would note is just, it is very concerning, the thought of the government stepping in and trying to regulate if speech is sort of conservative enough, or it is liberal enough, or it is talking about a particular topic enough. I mean, we certainly had that with the fairness doctrine back in the broadcasting days, and that was struck down. I think people generally know that that was a very bad idea, and that was harmful to public discourse and the level of discourse in the country. And we certainly would not feel comfortable going that way again. I think that should raise a lot of red flags, particularly if you say, well, for example, under the Trump administration, if you said, well, it's okay because, Republicans are in charge, and now you have not Republicans in charge. And, do you want a bureaucrat who perhaps you didn't elect making those decisions? To me, I understand the concerns about sort of corporate power and things like that, but I feel more comfortable with the private sector doing what the private sector does than having government somehow be involved in dictating my speech online. So those are our main views on this, and I appreciate the chance to share them. Thank you all for the conversation, and I'm happy to answer questions or chat with panelists some more. Let me stop sharing.
Thanks, Jamie. So I think everyone should get a sense that this is a complicated area. Obviously, you've heard two contrasting viewpoints. So I think one question here from Derek would be useful for both John and Jamie, and of course, Professor Frieden can weigh in on this. So this is a question from Derek Holland, and here it is. It seems one side of the aisle wants misinformation regulated within some reform of Section 230, while the counter argument to this centers around a claim of ideological bias from big tech. Is compromise on Section 230 reform possible when Congress seems to have a foundational disagreement on what constitutes a fact and what constitutes misinformation?
I think that's a great question. And to Jamie's point, because we haven't coalesced around any particular concept of what it is that we think should happen on a bipartisan basis, it's difficult to imagine that we do anything in the near future. Perhaps the answer to this could be, studying it more deeply. I tend to be kind of against studies. I think they don't really solve problems like this that are moving faster than legislation as it is. But until we can find a way to be able to talk about these bigger problems, the foundational problems, it's going to be a challenge for us.
Yeah, I mean, I think I would agree. And I should say, right, so John and I both actually had worked together. So he's still up on the Hill and I'm not on the Hill obviously anymore. So I think we've fought these battles and we sort of know, right? I am skeptical, not to say that I don't think Congress sort of has best interests at heart. I think they do. And I think folks have genuine concerns, which, are valid and they feel them. But I do think that the discussion is too far apart. As I said, I guess if folks were talking about just flat out repealing the law, maybe you could get sort of a bipartisan majority. It's certainly not what we would want. But other than that, I don't know.
I'd like to just chime in briefly by suggesting that I think conferences like this really help instill what I call digital literacy. It's really important, I think, for consumers and participants in social networks to know the consequences of data mining and data analytics and the value of their consumptive behavior. I mean, in the agreement, the social network subscription agreement, basically subscribers agree that their wants, needs, desires, location, emails, maneuvering across the internet can be tracked. And it was mentioned earlier that if you're paying $0, you're the commodity. You're the surveillance target. And the second thing to note is that social networks aren't charities. They are profit maximizing corporations, and they are triggering what economists call negative externalities or whatnot. But that's what you would expect from them. You have to recognize that if they want stickiness, if they want engagement, if they want to get you subjected to as many commercial pitches as possible, they are going to provide the most compelling, provocative content as possible. And if the consequences to society are harmful, well, that's somebody else's concern.
You're muted, Stuart.
I'm sorry, I'm back. So Jamie was mentioning, obviously, relations between the US and China and innovation, the innovation race. So I'd be interested in any perspectives from any of you regarding how you think the rest of the world looks at this. One of the things that the United States has been trying to promote in multiple administrations is this notion of global internet freedom, that we want to be the beacon of the world in terms of promoting as much unrestrained speech on the internet. And obviously, when we have countries like China, which are highly restrictive, that sets a contrast for the rest of the world, which may be useful for our foreign policy advocacy. So the question is, do you think that this is something that has larger repercussions outside the United States? Because clearly Facebook and Twitter and the larger social media platforms, YouTube, are global services. And so they clearly are not just restricted to what's happening in the United States.
So I'm happy to chime in. Yeah, I mean, I definitely think it does, right? And this is actually, there's been 230 language in different trade agreements that we've had. I know that there was some push. I know Senator Portman and a couple others have tried to get it out of there recently. So I don't know what the status will be, and maybe John does, but I do find it interesting that sort of here within the US, we're fighting about it, but then as we face outward, it's still there, right? I mean, we're still sort of saying, hey, we're the US and we want to import our US values as far as us vis-a-vis the rest of the world, which I think is the right thing to do. I mean, I wouldn't have it a different way, but I think it's sort of an interesting perspective. And yeah, I mean, as I said, I think it is a US sort of specific thing, and I don't think that's bad. I've been on panels with folks from the EU, for example, and they approach things differently. And, you know, in a way that sometimes I think is more challenging for members. And when I say our members, that doesn't necessarily mean Facebook, with no disrespect to Facebook. But, you know, we think about how smaller members, even mid-sized members, right, who are not Facebook and not Google and not Twitter, right, ones that don't have that size and that scope can do this, right? And they're just getting to be upstarts, or they, you know, are moderate business and they want to expand outside of the US, right? I mean, how can they comply with sort of more restrictive, you know, criteria on how speech is sort of checked and monitored? And is that a value we even want to be exporting to other countries? I don't personally think so. But yeah, I mean, I think it does matter internationally.
Yeah, I agree with that. I think from a trade perspective, it's interesting to see this as part of the discussions. One of the reasons that I've heard from several senators that wanted to leave this out, it wasn't because they didn't want to change 230, it was because they were afraid that by putting this in an agreement that we were agreeing to with other nations, that we were basically handcuffing ourselves from being able to change our own statute and do things differently domestically. So from an international perspective, you should also kind of think of how the Europeans have looked at this. Traditionally, they thought that the Americans would be the ones who would lead here. I think you saw that with data privacy. They waited decades, and when we didn't end up passing something comprehensive, they passed GDPR, and that's beyond the scope of what a lot of companies and certainly the members on my side of the aisle think we should be doing for protecting consumer data and how harmful that is. But to Jamie's point, if you're a company like Facebook or Microsoft, you have the compliance infrastructure to be able to deal with whatever government's going to throw at you. I'm more concerned about how we keep a competitive environment possible for not just this generation, but the next. And if we're not able to build the right kind of framework, like the way the 230 was in 1996, it's going to be difficult to imagine that we'll be number one still and be as competitive and have products that are so incredibly compelling the way we do today.
I could offer a little bit of a historical perspective about the potential for sort of splintering the internet into different intranets and the firewalls, Great Firewall of China and the like. Back in 2012, there was a move afoot at a conference of the International Telecommunication Union, where a number of countries sort of because of a one nation, one vote structure, wanted to vote to, in a sense, create a portfolio for this UN-based organization, the International Telecommunication Union, to have a wingspan or a jurisdiction over internet governance. But it was really a thinly veiled strategy to legitimize sort of carving out a variety of pretty draconian blockages to open access. So I worry that, you know, in terms of the court of public opinion I've mentioned, and in terms of being accused of hypocrisy, that here we are restricting speech at the very same time as we've been the standard bearer for open access or whatnot. So there's a messaging issue globally that I'm worried about in terms of trying to finesse a hard concept where internet governance and jurisdiction by UN-based organizations and the issue of platform moderation are sort of conflated, brought together.
And I think, yeah, I appreciate you saying that, because I mean, the new IP issues with China aren't really going away. They just sort of get quiet and then they come back again when the ITU comes around, and then they sort of get quiet again. And I don't think they're going to go away. I think we'll see it, right? And I mean, there's all, and I do cyber issues too, so I feel like I live in this, but right, I mean, there's issues with Huawei and there's issues with ZTE, and there's sort of issues about, you know, if we have splintering, as you talk about, do they just go off and sort of do their own thing with the countries who want to be with them, which is not the US, that and I guess now maybe it's not the EU anymore either, but you know, what are the values that we want to import to other countries? And do we want the internet to be a global thing, or do we just want it to be with, you know, those countries that sort of share our values? And so it's more than just, right, like, did we kick President Trump off Twitter, right? It goes well beyond that. And so I think that's the thing that policymakers need to keep in mind as they're thinking through how we change this.
I think that's a good point. If you're looking at what China's doing, the sheer scale that they have with not just the reach they have in their own country, but what they've been doing in Africa, it makes it very difficult to understand how much equipment you need or how many users you need to be competitive with that from a standard setting practice. And to the extent that we're falling away from agreeing with the Europeans on things, I think it's only to our detriment.
So what if we woke up and there was some consensus reached and Section 230 was changed, so there was some liability that would now attach for carrying this content. So what do you imagine that liability to look like?
I think a lot of the proposals that have come out have focused on if there is a certain kind of harm that we're able to speak to, that when that's present on the platform, the companies have this positive duty to go out there and remove this. And if they fail to do that within certain notice requirements, then they're eligible for some kind of a lawsuit. But you've also got to think about whether or not you're defining a new tort in this process. That's something that we're trying to be mindful of and to not do. That would be a boon for trial lawyers. And, you know, there are a lot of people who are going to go hang up a shingle and make a whole lot of money in this cottage industry that's not solving problems. It's just taking things to court. So that's really the tension that we're looking at, and we're trying to identify harms to the greatest extent that we can and be clear in the legislation that we're writing without being too prescriptive and telling companies, here's how you can speak, because there's been a constitutional tension there with the extent that we're able to actually tell companies what you're able to say.
Yeah, I'm afraid similarly, it would end up like a cottage industry. So similar to under the TCPA, which is basically robocall statute, you see class action attorneys that just, you know, send out sort of predatory letters to companies who maybe haven't even done anything wrong, where they just look for people and send out letters and say, hey, you can get up to $1,500, you know, per instance of whatever happening. And that's not what we would want, right? We wouldn't want people to be sort of trolling websites looking for something. I certainly wouldn't want also every content moderation decision to turn into a trial. So Facebook has its oversight board, which is sort of an independent appeal body, and it's an interesting experiment. And I don't really have an opinion on it one way or another at this point. But I certainly wouldn't want every content moderation decision to turn into like, you have to have a full-fledged appeal before I can post a photo of my 3-year-old on Facebook and make a joke about it. That just, I mean, the internet can't function that way. And you know, nobody's going to want to be on an internet that functions that way. So that's certainly what I wouldn't want. Our companies are also concerned because there has been some talk about things like, you know, share your algorithms. And that's hard, right? Because their algorithms are, you know, that's their proprietary information. That's basically how their entire business runs. And we certainly wouldn't ask, right, like a medical, you know, like a medical company that's creating a cure for a disease, right? Like share your ingredients that you use to make this disease. So we know that, you know, I mean, besides FDA safety, but like share it with your competitors for the sake of sharing it with your competitors. I think that that is concerning, and they're not comfortable at this point with doing such a thing.
Jamie, when you mentioned the 3-year-old, I'm mindful of the another model involving copyright, the Digital Millennium Copyright Act. They have a notice and takedown mechanism where basically you take down the content and you know, discuss whether to put it back later in time. So you have these worst case scenarios where a mother is taping her 3-year-old cavorting to a very scratchy couple of seconds of Prince's Let's Go Crazy, and it turns into a big litigation over so-called fair use, and students know about fair use and academics know about fair use. So I don't know if the DMCA is a good model. It creates that cottage industry of litigating, and it doesn't necessarily solve the problem. It's over-inclusive and under-inclusive in equal measure.
So if we were to reconvene a year from now, do you think anything will change other than the fact that we're continuing to have a discussion and that there are different viewpoints on this? But do you think that there will be anything a year from now beyond the discussion phase?
I hope by then we've coalesced around a singular problem that we're trying to solve, and that we're able to say we'd want to move in one direction or another. But that's probably about it for now.
I mean, I guess my secret fear, right, is that Department of Commerce is going to go at it again. They won't get the FCC to do something, but who knows? Maybe they on their own can sort of figure out something, or they can convince them, depending on who ends up being permanent chair over there, that there's something that needs to be done. And then I feel like I fought that battle there and I won already, and I don't want to have to do it again. But that's sort of the way that I would see this playing out if something were going to happen. Not to say, once again, that Congress like can't get their acts together, but it's just a very tight margins these days, and there's a lot going on.
So this is for John McNair, who is our tech wizard. So John, I think it'd be interesting now that we've done a pretty good deep dive on this, first of all, to ask our audience again in terms of do they feel a little more knowledgeable about Section 230 than they did at the beginning? And then after we get that information, feed it back, then I have another question, which is really related to where you, the audience, would fall in this spectrum of debate. Do you think that Section 230 should essentially be retained as it is, life goes on, or modified or changed in some way, leaving open the different types of mechanisms for changing it? So it would be a change versus no change question. I think it might be interesting for all of us to see what the results are. So John, is it possible for you to craft a couple of poll questions for us? The first would be, are you more aware after this discussion about Section 230? And hopefully we're going to get a very, very high proportion of people. And that should pop up very soon here. Okay, John, I don't know whether you've heard me or Ann.
I can hear you, and I'm sure he's working on it.
Okay, great.
And I am working on it.
Okay, I'm sorry.
I'm going to vote yes, just to make sure someone votes yes.
Okay, and while we're doing this, obviously, if you have any further questions or points that you'd like to raise, so I see one in Q&A. So again, from Derek Holland, considering the concept of harm, wouldn't an overhaul or repeal of Section 230 basically change the application of libel law in the United States?
I guess I'll go first on that. I don't think that it would. We're looking at the same kind of bars that you have to clear for any other kind of suit. The reason that we want to have this procedural hurdle in front of companies is so that they're not having to spend time lawyering up, especially if they're a smaller company and just don't have people on retainer who are able to deal with this kind of complex litigation. Because even just going through the pleadings, it's going to take a little bit of time. It's going to require some money, and every time you have to do that, it's just this extra expense. So that's really the way that I think it would be an inhibitor, or it'd be something that would change things. I'm not sure that it would actually change the law unless we created a new tort.
Great, thanks. And Derek says thank you. So back to our poll here, just asking whether you feel a little more knowledgeable on the basis of our discussion. So that's a yes or no. And then once we have that, the second question would be whether or not you think we should retain the status quo, do nothing, or change it in some way. here's the first question. Are you now more aware? So it's yes or no. And if you just click on, we'll see what the results are. %. Well, that makes all of us very happy. And certainly from an educational standpoint, I think part of what we try to do in Social Media Week is to be able to develop and deal with topics which either complement or supplement what students have in class. And so I think I feel good about that, and I hope all of our panelists do as well. So let's go to that final question about changing Section 230. So again, simple yes or no. Do you think, given what you've heard, what you're thinking about, that Section 230 should be kept as it is or changed in some way? And that would be for whatever reason you think. And here we are. So we have a retain 40% and modify 60%. And I think the next time we do this, maybe we'll do a baseline to find out at the beginning of the discussion, to ask the people who are aware how they feel about modification or not, and then maybe look at it at the end and see whether or not their views have changed on that. So I'll just leave it open now if there are any final questions, and I'll just look here in the Q&A. If not, I'd love to thank our wonderful panelists. So Professor Rob Frieden and Jamie Suskind and John Adami. I think you've done a great service to us here at Social Media Week in terms of exploring these issues with us. And also they have real practical implications, because probably as soon as we log off Zoom, we'll be back on social media dealing with these content issues and experiencing them firsthand. So have a great day, and thanks so much.
Thank you. Appreciate it.
Thank you.
Enjoyed it.
Thanks all.